contracted Fuquay Inc. in spring of 2020 and still had not paid them. Isn't that right?
What's your question?
That THB had contracted or retained Fuquay Inc. to do work on the sanitary sewer system in the spring of 2020, but had not paid them at the time of its pay applications 10 and 11.
That is correct.
And you understand that Fuquay Inc. filed a lien on the property after you were terminated?
I believe that's right. I believe that's correct. Yes, sir.
Okay. You also understand that in your pay applications 10 and 11 that you represented to Canterbury Cove that all of the surveying work was done.
Well, we had the survey done for our part of the job. We don't do the as-built.
Okay. But you understand that for purposes of what you represented to Canterbury Cove in your pay applications in both April in 2020 and then again in May of 2020 for the one that was attached to your lien, you represented that all surveying was done and paid for, right?
That's what it says. Yes, sir.
And as part of your pay applications, you certified in every one of them that all of the money was going to go to pay or had paid all of your suppliers or laborers, correct?
That's correct.
In July of 2020, THB Construction was sued by D. Martinez Surveying, right?
I'm not sure the date, but yes, we did get served, and yes, they have been paid.
And so your lien that you filed against Canterbury Cove was filed, I think, on July 10th. Is that correct? Does that sound right? We'll look.
I'm not for sure, sir.
Yeah, let's just look because I want to get the date right. July 15th. On July 15th, if you look here on the screen, let me put it on the screen for you.
I need to enable that. Just give me a second.
Thank you, Your Honor. Sorry, I should have asked first.
Go ahead. That's okay.
This is Plaintiff's Exhibit 1. This is your lien here that's recorded. And it's recorded on July 15th, 2020, right?
Yes, sir.
And on June 15th, 2020, you had been sued by D. Martinez Surveying for unpaid payments related to, at least in part, Canterbury Cove, correct?
Yes, sir.
So it wasn't correct. It wasn't true that your certification wasn't true when you made it in May of 2020 and April 2020, that 100% of the surveying was done and that you had certified that you had paid them entirely.
The surveying was done. We just haven't paid. We just hadn't paid them yet.
Okay. One of the elements in your lien that you filed is work related to change order number 4, correct?
I believe so. I'm not going to show me the paperwork about it. I don't have it in front of me, unfortunately.
Yeah, let me bring it up for you.
Thanks, sir.
This is Exhibit 1. This is the lien. And then this is the pay application on number 11. And here you can see, let me zoom in for you. Change order 4. Can you see that there? Then the blue.
Yes, that's for the extra concrete.
Yeah, the extra concrete and the on-site dirt, right?
Correct.
So that's roughly 14,450 and 37,500. Those amounts were part of change order number 4.
Yes, sir.
And you agree with me that Mr. Reeder didn't actually agree with change order number 4 before you submitted this pay application?
He didn't like paying it, but you know, at the end of the day, he knew it had to get done to get the job completed and sold.
But he never agreed to these amounts, right?
You know, I
think you hit the wrong button, Mr. Boney.
Mr. Boney, we can't hear you.
Can you hear me now?
Yeah.
Okay. What happened here?
There you go. Oh,
There you go. Okay. The dirt work, you know, it was done as we're getting it done. I don't recall if I gave him a price up front to go do it or afterwards, but that's what it costs. The concrete work was just a addition of the extra work that we got done with that price.
okay. But you agree with me that Mr. Reeder didn't agree with these numbers and never signed a change order that said we're going to pay you these numbers, even if he agreed that work may or may not have needed to be done. He never agreed to these numbers, right?
I never agreed to them. You're right, but the work had to get done to get the job completed.
Okay, and Exhibit 57 was the change order that you submitted to support that after you submitted the pay application, or at the same time you submitted that final pay application in May, right? Can you see that?
Yes, on May 25th.
That's right, and it's not signed by Canterbury Cove, correct?
That's correct. On that paper there.
That's right. Well, you never signed it, right?
Far as I know.
And you agree with me that the contract requires all change orders to be signed, right?
That's always helpful that happened before.
In fact, paragraph 8.1 of the contract requires work shall be authorized by a written change order signed by the owner, right?
I see that. Yes, sir.
Okay, so you never got a signed order and you never got his agreement to those numbers, but you included it on your lien amount.
That's correct. The work has already been done. Money's owed.
All right, but you don't, other than what you put on that pay application, there's no other supporting documentation for the value of that work, right?
No, that's it.
Okay, with respect to the trees, you understood that Mr. Reeder had deducted that amount from pay application number 10, right?
Yes, sir, I do.
And I think you testified in your direct that you disagreed with him at the time.
100%.
But did you ever send him an email or anything in writing that said you disagreed with him or reserved your rights to charge back that amount?
I have no idea if anything in writing. Verbally, I told him the day he cut my check in his office on Canterbury Cove, this is not right, Bart. I don't agree with you on anything. We'll have to work this out. This is not right.
Okay.
And he knew I was not happy.
Do you remember?
There was no misunderstanding there.
So it's really clear in your mind, something you really remember?
Yes, vividly.
Vividly? And
yes.
do you remember giving a deposition in this case?
I do.
And do you remember telling me in your deposition that you had no disputes with pay application number 10?
I don't remember that, no, sir.
Let me show you. This is from your deposition, and you see here where it says, do you have any recollection or knowledge of any disputes related to the payment of draw application number 10? And your answer is, I don't know, I don't have anything.
I do see that. Maybe I have that draw in front of me or know what we're talking about at that time. But the draw application number 10 regarding those trees, how he cut my check to offset what he thought the tree mitigation was supposed to be. And yes, I do have an issue with that.
Okay, so today you vividly remember that conversation, but during your deposition, in response to the question of do you have any disputes, you said you didn't know and you don't have anything.
Correct. I guess I had the paperwork in front of me or misunderstood the question.
All right. Do you agree with me that the phase 2, that you did phase 2 work as part of the work you were doing in phase 1, right? You, like the sanitary sewer work, you laid that in phase 2 because the pipe was delivered while you were doing the phase 1 work, right?
That is correct.
And you understand that the contract specifically provides that payments are not due on phase 2 until that work is approved by the city and the owner.
Well, those draws, work is done on progress draws.
I
So
understand.
once work is done, what do you get paid for it?
I understand that, sir, but in order for you to get paid on the sanitary sewer work, it has to be approved by the city, right?
Well, on the progress payments, no. We do the work, the city's already there. They kind of looked at it. The city looked at the utility work on phase 2 as we're laying it.
Okay, but this isn't a progress payment. This is a lien payment for a final payment to close out your relationship with the city or with Canterbury, right?
Correct, because Bart Reader terminated our contract.
That's right. And at that point, you would agree with me that he can't pay you a final amount on phase 2 until the city has approved it and he knows whether or not it is actually approved and not and free of defect. Doesn't that make sense?
No, he terminated our contract. The work has been done. The money is due.
Okay, but the
If he
express,
wouldn't have terminated my contract, I would have had it TV'd and certified. He didn't allow me to do that.
the express, you agree with me though that the express terms of the contract for final payment require that the work's been fully performed and accepted by the city and the engineer, and that you've provided a waiver and release. I mean, that's what it says right there, 3.4, right?
Yeah, I see what it says, but when you terminate someone from a contract, you don't allow that person to complete that step. So is that money just free?
No, I think the question is whether or not it's owed to you after the city has approved it and he knows what the lawful deductions are in case there's defective work, right?
We never got to that point.
Right. The city hasn't approved phase 2 yet, which is why it's premature payment, right?
I don't say it's premature. The work's been done. We have a line item for installing pipe. We have additional line item for testing and TV.
Okay. With respect to your affidavit, you filed this lien in July of 2020 after you were terminated, right? We talked about that.
I don't know the dates on top of my head, but
July 15th
sounds right.
is recorded. Okay.
Okay.
And as part of that lien, you submitted an affidavit that supports the lien, correct?
Yes, sir. That's correct.
You signed it,
Yes, sir.
and you said you swore it out under oath, right?
That's correct.
And you have in paragraph 6 the amount unpaid for such work and or materials in which is now due and owing to claimant for work in April, May, and June 2020, and including retainage, is $370,635.32. This amount is true, correct, and just, with all just and lawful offsets, payments, and credits known to Affy and allowed. Did I read that right?
You did.
And so that's your statement under oath and penalty of perjury.
Yes, sir.
And it's not true, is it?
No, it is true. The work's been done. He terminated us from our contract. The work had been done. The pipe has been laid. The city was out there every day as we're laying the pipe. If he didn't terminate us from our job, we would have had it TV'd and tested.
Okay.
I can't help Art terminate us from our contract where we couldn't perform that last task.
$370,000, that number's not accurate, right?
Why do you say that?
Well, you've already abandoned your claim for the $20,000 in maintenance bond, so we know it's at least $350,000 and not $370,000, right?
Okay.
It doesn't include you include a re-invoice for trees, right?
Yeah, the tree work, he took the money out of our contract, out of our payment.
But
That money is due to us as well.
okay, it includes an agreement for monies in change order 4 that was unsigned and never agreed to by the owner, right? That $370,000 number includes numbers for a change order that was never signed and agreed to by the owner, right?
Yes, sir. The work has been done.
It does not. It includes the amount for phase 2, which is not yet due and owing because it's not approved by the city yet, according to the terms of the express contract, right?
That's what it says. The work has been done.
And it doesn't include any offsets or payments or credits in favor of Canterbury Cove at all, right? You just assume that you get the entire amount of monies that you're claimed without any allowance for what Canterbury Cove may have to deduct for additional expense items to correct work or finish work.
That is correct.
So if the judge thinks that this number is overstated, this paragraph is false, right?
If the judge thinks that way, but we can dive into what you think is not correct and later in this trial.
I think we've done that the whole trial, so I will leave it at that and pass the witness.
Any redirect?
Yes, Your Honor. You can pull up Exhibit 138. Okay, got it. Okay. It's not showing up on.
Can't see 138.
Just a second. Okay, Travis, you weren't listening to testimony yesterday. This was Exhibit 138 that was presented by Canterbury Cove. You reviewed that now, correct?
Yes, sir.
Okay, I just want to go briefly one by one on this. Let's go to Exhibit 68.
68, you said?
She's going to bring it up to you, and you may have a hard copy in front of you, but she'll put it on the
Okay.
screen as well. Okay, and it's an invoice from Cardinal Strategies relating to updated SWPPP plan. In reviewing that, do you believe that's a responsibility of THB to pay?
No, sir.
Why not?
Because this bill was created after the city shut our job down. And these were items that Bart should have paid us for to keep the project out of the cities where they wouldn't be in compliance, where they would be the city wouldn't shut us down. You know, on the stormwater plan of our item, their scope of work, we install a silt fence one time. If natural causes come, the wind, the rain, the sun, it beats up and destroys the erosion control measures that we already have set in place, that comes as a maintenance issue for the owner to pay for. Bart never did want to pay for anything extra. He just thought that was my job. I said, no, it's not my job, Bart. And so we kept rolling down the road here, and the city comes up, nope, job shut down because erosion control measures are not in working order. And so then we had to go and fix that. And then Bart had to have Cardinal come out for a extra inspection to come do this. So no, if Bart would have done his job correctly, we wouldn't have had this. We wouldn't have been shut down from the city, and Bart wouldn't have had to have a special inspection report to get this job reopened.
Okay, let's go to Exhibit 67. And it's referred to as an as-built surveying work for 2814.
Okay, I see that.
And do you understand THB to be responsible for that particular payment of that invoice?
No, sir, I do not. We don't have a pay app item.
Travis, why do you feel THB is not responsible?
One, we don't have a pay app. We don't have a pay item on our contract for as-built. And this invoice I'm looking at doesn't say anything that they did. It doesn't say as-built or anything else. It just has a lump sum total here of $2,814.50. And we don't do, as historically, contractors don't pay for the as-builts. The contractor's job is to build a job according to plans. If anything is changed or deviates from the plans, redline them, and then at the end of the job, give those red line set of plans to the engineer for them to make the as-built to give to the city.
Okay. The next category they list, and if we can pull up Exhibit 63, it's referred to as final grading phase 1. And on the first page of 63, there are 4 categories. I want to talk about each one of those. First is LS grade drainage channel for $6,000. Do you know what is being referenced there?
Yes, sir. That's the drainage channel there along Chisa Road that borders Canterbury Cove. And if you look at the grading profiles of the plans that we were instructed to build, that channel is not included in the scope of the work. So we did not do that.
Okay, so with it not being in the scope of the work, it's not something that THB contends it had responsibility to do.
Correct. It was not our responsibility to build that channel.
Okay, and as such, if they're trying now to bill THB for that, THB would contend that it had no contractual responsibility for that work. Is that correct?
Yes, sir. Correct. Correct.
The second category, it says LS daily rating, and has 3 days at $2,000 a day for $6,000. Do you believe THB is responsible for that $6,000?
No, sir, I do not. Before I left the job, I went and made sure all lots were balanced, everything drained, everything was plus or minus 3/10. And a plus or minus 3/10 is a national standard of dirt work construction for finished pads to be acceptable to sell back to the city and also developers because they can start building houses on.
Okay. And so at that point, at the time that you left, you was not aware of grading issues?
No, sir.
Okay. Okay, let's go to the next, just a small category, but it says LS meter can on irrigation service. You know what that's referring to?
Yes, they're referring to an irrigation service that we didn't, that irrigation meter can we didn't install, but we installed everything on the job. There's only 2 irrigation services on the job. We installed both of them.
Okay. And the final category is LS clean and TV installed sewer line, and it references $4,275.20. Is THB challenging that amount?
We are not, because we were on the job the same time that Bart had Magnum on the job. I had my cleaning truck there ready to go do the work. Bart comes up to me, Travis, you're already kicked off the job. You're terminated. I hire Magnum, take you and your people off my job. I said, okay. So I was going to do the job anyways. It only cost me about the same money. So I don't contest that charge.
Okay. Let's go now to Exhibit 131.
Okay.
Which is an invoice from Strand Concrete for $14,812. On the chart that we looked at 138, it shows $12,812. Does THB contest that it's responsible for the amount in the invoice?
Yes. So when I left the job, go ahead, Scott.
I was just going to say, as a question for him, tell me why THB contests that it's responsible for that amount.
I don't feel like THB is responsible for any of this work. Before we
Okay.
left, I had all the concrete work patched up, cleaned up, ready to sail.
Had,
Already fixed all the cracks and issues in the concrete work.
had there been a formal walkthrough with the city at the point that THB was terminated?
We did not have a formal walkthrough because the city wouldn't do that until Bart Reeder got all the landscape issues done on the job. The only thing I had was verbal communication with the inspector, whose name was Dan Abel. And so I corrected everything that Dan wanted done verbally, but nothing was in writing because Dan wasn't going to do a walkthrough until Bart had all the landscape issues fixed and finished.
And the landscaping was not the responsibility of THB, correct?
Correct.
And looking at, what's the date on the invoice from Strand Concrete?
It is 10/15/2020.
Okay. And approximately how many months after y'all left or were terminated is this invoice?
You turned me back in March, Scott. Is that correct?
Well, okay. I guess there's previous testimony that in June of 2020 is when it was termination, and that y'all left.
So it's been 4 months then.
Okay, next category, let's go to 128.
Okay.
And that references a raised water meter tap. Does THB contest this amount?
Yes,
Okay, and why?
because before we left, we already raised all the water meter cans, the water valves to grade, to appropriate height.
Okay. Let's go to Exhibit 128. I'm sorry, 64.
Okay.
And that is reference to City of Rowlett required corrective work. Is THB
Yes, sir.
it's responsible for the amount of $3,500?
I don't know what the corrective work was. When I left the job, I verbally talked to Dan Abel, the inspector. He said, yeah, everything looks good, Travis. Waiting on Bart. So I'm not sure what they had to go do that the city wanted to be finished up.
And what's the date on the invoice on 64?
10/28/2020.
Okay, so again, months after THB then left the job site, correct?
Yes, correct.
Okay, let's go to then Exhibit 129.
Okay.
The category identified by Canterbury Cove is street cleaning and erosion control. Does THB dispute that it would be responsible for such $1,800 charge?
Yes, sir, we do. Before we left, we had the streets cleaned and the erosion control stuff, well, it wasn't ours anyways. And if you look at those exhibits on 129, I guess that carries over to all of his, never mind. Yeah, because it on 129 shows here 4,650 feet of Kerlex that will never in our scope of work. That also has here mowed, roadside, and spread seed. That was also never in our scope of work either.
Okay. And they also identify Exhibit 130 for this. You could pull that up, Patty.
Yes, sir. I see it.
And that apparently is also part of the $1,800 charge. Is that work that's there also disputed by THB?
Yes, sir. 100%. You know, after we left, the streets were, before we left, the streets were already cleaned. It also says spread weed killer. We don't spray weeds, so that's not our scope of work either.
Okay. Let's go to Exhibit 5.
Okay. I'll see it here.
Okay, and appears to be a charge for a maintenance bond of $8,516.
Okay.
THB dispute that it would be responsible for such maintenance bond.
That's correct. Yes, sir.
Okay. And why does it dispute that?
Well, one, you know, if they're going to charge us maintenance bond, we already charged them the $20-something thousand for it. So if they're going to charge us $8,516, then they should pay us the difference in what our charge is. So $20,000 is around $12,000 back to us.
Let me ask this: in the scope of work and quantities, is the maintenance bond cost a cost of the contractor, THB, or the owner, Canterbury?
Well, the contractor pays for the bond out of the money that the owner pays for the bond.
Okay, let's look at Exhibit 5. And let's go to the third page of that. And this has been discussed previously as quantities, et cetera, but what is, I think she's circling that. It says maintenance bond, $21,273.78. What is that then showing to you?
It's showing that's a 2-year maintenance bond at 20%.
Okay, that out of the contract price then of the $1.668 million, then the contractor, I'm sorry, Canterbury would be paying the cost of the maintenance bond. Is that what that's showing?
Correct.
Okay. So going back to the request we looked at in 65, then do you know how Canterbury seeks that THB pay the maintenance bond?
No.
Okay. I'll pass the witness.
Anything else?
Yes, Your Honor, I'm sorry. Apologize. Mr. Boney, I'll talk a little bit about the Cardinal Strategies invoice.
Okay.
Pull
that back up here. Hold on.
It's your contention that was for work that Canterbury Co. was supposed to have paid for?
That's correct.
You understand that is for work that was done to do an expedited inspection after they remedied the SWIP violations, right?
Yes, sir.
In the SWIP violations, it's just your contention that's Canterbury Co.'s problem, not your problem as the contractor on the project?
That is correct. And the reason why is because these are mainly maintenance issues of the SWIP plan. Our scope and our billing there was a one-time thing, no maintenance on it.
What were the SWIP things that were maintenance?
They had to replace some silt fence, redo the rock construction entrance.
So it's your contention that even though THB is responsible for installing the silt fences and the rock entrance, that they don't have to upkeep it under the contract, that Canterbury Cove has to hire someone else to upkeep it?
They had to hire somebody else or pay THB to fix the maintenance issues. Natural wear and tear is a maintenance issue.
And you never submitted a pay application to do that work for them, right?
I'm not for sure.
The second thing I want to talk about is the as-built. You never provided as-built surveys to Monk Engineering, did you?
No, it's not our scope of work. We provided them red line set of plans to where Monk could do the as-bills.
Did you do that, or did you just tell Monk that they were built according to plan?
No, I had Don Peak, he works for us, drive over and give them a set of plans for the as-bills.
Do you know if the as-bills adjusted for the surveying the elevation differences occurred because of the grading work you did?
Is your question, I don't think, did the as-bills reflect the difference in grades?
Yeah.
I don't know. I never saw the as-bills after they got done.
You never saw the as-bills?
No, I never saw the revised set of plans after Monk got, after whoever, I guess Cardinal here, not Cardinal, but the survey company that Bart hired to make up the Devin Davenport Meadows. You know, CBG survey in Texas. I don't know if they did that or not.
If the work you did changed the elevations, it's just your contention that you wouldn't have to pay for surveying to make sure that the as-built were consistent with the way it was actually built.
Correct.
Okay. You indicated that the drainage ditch and grading work was not within your scope of work, and that's why you're not responsible for it, right?
Yes, sir.
And do you recall receiving a punch list in June of 2020 from Canterbury Cove before you were terminated that specifically included that work?
I vaguely remember something from Bart.
Let me show you Exhibit 99. You see this document for a punch list for THB dated June 2nd. That's about a week and a half. It's supposed to be done by June 10th, correct?
That's what it says. Yes, sir.
And it includes a whole bunch of grading items, correct?
That's what it says. Yes, sir.
Including the ditch alongside Cheesa Road.
That's correct.
So it was within your scope of work. You were talking to
No.
the reader about it.
We were talking about it. Yes. Well, never scope of work. Bart thought it was in our scope of work.
So you were going to tell him in response to this punch list that we're not doing that?
That's correct.
Okay. You never told him that, right?
No, I told him that, we weren't going to do it under scope of work. My dad told him the same thing.
All right. With respect to the Strand concrete invoice, you said that the concrete was ready to go, right?
Yes, sir.
But you weren't present for any city of Rowlett walkthroughs or inspections or anything related to the concrete after you were terminated, correct?
That's correct.
So if there were defective issues that needed to be corrected, you have no idea about that. You just think it was done right.
Well, based on my historic knowledge of industry standards and what I saw on the job when I left, it was acceptable.
Do you think that Canterbury Cove spent $12,000 to respond to the city's request for corrective work just for fun?
I don't think it's fun at all. I don't know if that's the right word at all. I don't know what they did exactly. I have a bunch of items here, but they tell you where they were or what they actually had to go do. Because there was 4 months after we got terminated, somebody else could have been in there and damaged the curbs with a backhoe, a skid steer. Put that repair back on me. I don't think that's accurate.
Yeah, but you don't know if any of that happened. All you know is that you were terminated in June of 2020, and according to you, you did everything right, and Canterbury Cove did have to do corrective work.
Well, I don't know if they did or not. I wasn't there. I wasn't present. All I'm saying is the invoice that y'all provided to me.
Okay. You see you talked about the irrigation tap. You see here on this punch list that was on your punch list and you hadn't started fixing that yet?
Yeah, I see it's on Bart's punch list. Yes.
So all of these items that are on Bart's punch list, now your argument here today is that these just aren't issues that were within your scope, so you didn't have to do it. but before you
That's
were
not what I
terminated,
said.
I think that is what you said, but we'll let the judge decide that. But your argument now is since we were terminated, we just don't have responsibility for this stuff.
We don't have responsibility for it. If it was put in the ground and working functionally, there's no recourse that after 4 months, after I was off the project, they had somebody else come back and do whatever they think needed to have done. They could damage these issues and say, yeah, it's Travis's fault.
Yeah, but you have no evidence that that actually happened.
Or does that any evidence it didn't happen either? They just know
I mean,
that they had to go hire somebody to go do it.
Other than him swearing under oath that they needed to do these things to correct it to get city approval, and the fact that they spent money, other than those two things, there's no evidence, right?
Correct. And where's the guy who did the work for him? Where's his testimony?
I don't know. You should ask your lawyer about why he didn't call him. You also talked about the silt fence wasn't done. I think the Curlex silt fence. What was your understanding of your responsibility under the contract for providing silt fences and erosion control?
No, that invoice was for Curlex. We didn't have Curlex on our invoice.
Okay.
The billing. Curlex is
explain to me what
product.
Curlex is. Explain to me what Curlex is.
Curlex is a green woven mesh product. They make it in 4-foot widths and 8-foot widths, and they put it behind the back of curb to keep dirt from washing into the streets.
Okay.
It wasn't in our contract.
Well, it wasn't in your contract because you decided not to use it, but that doesn't mean that the erosion control wasn't necessary and the new inspector did use it, right? Our new contractor did use it. That's just
Well, it wasn't our scope of work, and we weren't asked to go do it. And Bart was going to take care of landscaping and the Curlex himself.
you don't think erosion control is part of your contract?
Erosion control, that's a big word you say. I cast a lot of nets there. You know, I broke it down: silt fence, rock entrance, concrete washouts on my proposal to Bart. Those are the items that I was going to be responsible for. Putting them up. Maintain them is different. There was nowhere on there for Curlex. And Bart said he would take care of Curlex.
Isn't Curlex just a brand name for erosion matting?
Yes.
So if you're responsible for erosion control and they had to go replace the erosion matting because you didn't keep it up, that's a charge that you should have taken care of, whether you used Curlex or some other type of material, right?
Wrong. We put up silt fence around the perimeter of the job. Curlex was installed after the streets were paved in concrete and the parkways were graded. And he put that up when he tried to sell the job back to the city for erosion control practices.
Do you know whether or not THB, no, strike that all. I'll move on. You'd put in the phase 2 sanitary sewer work in the spring of 2019, right?
I don't forget the date. I'm not for sure.
It was well before your contract. It was part of phase 1 early work, right? When you got the pipe delivered.
Correct.
But by the time you were terminated over a year later, or roughly a year later, you still had not done any testing on it, right?
That is correct.
Okay. No further questions, Your Honor.
No additional questions, Your Honor.
The defense rest?
Have the attorney's fees issue. Can Mr. Boney be excused?
He can. What is the, I thought you guys had a stipulation now.
Your Honor, the stipulation is just as to Canterbury Co's fees. If you recall, we had a motion pre-trial that they didn't designate any experts on attorney's fees during this case and produced their invoice on Monday afternoon. So we just basically
Did you
said,
have a chance to check that, Mr. Hayes? Did you designate an expert or no?
No, Your Honor, we did not designate the expert. We've asked for fees in this case. They know that we've been involved in the case. It was inadvertence, but good cause, and they've shown no harm or prejudice. as to the receiving the amount of fees, and they're about half of what the plaintiff's fees are.
I mean, my inclination, I mean, if it's not designated, it's not designated. I don't,
Yeah, I mean, that's our argument, Your Honor. I think it's an automatic sanction of exclusion, but that's our position.
why don't we do this? So subject to the attorney's fees, you rest.
Yes, Your Honor.
Okay.
Yeah, and Your Honor, for just so you know, I mean, we don't fuss with the amount of the attorney's fees. So we have prejudice because it wasn't designated. We didn't do discovery, and now we potentially have a claim for attorney's fees that wasn't properly designated against us. But the amount, we don't dispute. So to the extent that Your Honor lets it in, Your Honor lets it in. But we just think that Rule 195 requires it to stay out at this point because it was late designated. It wasn't ever designated, actually.
All right, let's go ahead and take, so the folks in the Canterbury case, let's go ahead and take a quick, I'm going to meet with the other attorneys and take a quick break. Why don't you guys kind of sign back on in about 15 minutes? Hopefully we'll be done by then, or come back on in 15 minutes. For the folks in the Hume case, I'm going to take a quick break and I'll be back in about 2 minutes.
Can Mr. Boney be excused, Judge?
He is.